Cassie.
I'd like to call this public hearing to order. Please join me in the salute to the flag.
Allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Would you please read the legal notice?
Yes. The Ledyard Town Council will conduct a public hearing at 6:30 p.m. Wednesday, September 10th, 2014 in Council Chambers, Town Hall Annex, 741 Colonel Ledyard Highway, Ledyard, Connecticut, to receive comment on the proposed ordinance establishing citations and fines for inland wetland violations. At this hearing, interested persons may appear and be heard, and written communications will be accepted. Copies of the draft ordinance are available in the town clerk's office during regular business hours. Dated at Ledyard, Connecticut, this 28th day of August, 2014, for the Ledyard Town Council, Linda C. Davis, Chairman, published in the New London Day on September 9, 2014.
Thank you. Will there be a presentation, Kevin? Is that you?
Yeah. So we've had this before us at a previous date. There were some questions that were brought up during the previous public hearing, which caused it to go back to committee, since the changes that were recommended during the public hearing were substantive change to the document. So it went back to land use for referral for the review of the state statute. We clarified some of the language to be consistent with the state statute. Changes that were made was the voting method for the Wetlands Commission in order to approve the issue of the fine, which required a 2/3 majority according with the way the ordinance is drafted, the draft ordinance being presented. One of the other changes was changing the dollar amount of the fine from $1,000 per day to a $8,000 fine per violation, which is in accordance with the state statute. The other changes was as far as the appointment of the hearing officer, how that is done through the mayor's office, and then the payment of the fine. Also, in addition, that the payment of the fine does not absolve the individual of the violation. Payment of the fine also has to include resolution as well. And those are the changes that were made to the statute, the ordinance as presented.
Okay. Are there any public comments?
Yep.
Yes.
Hi, my name is Michael Washington. I'm the Vice Chair for the Wetland Course Commission. I stand here in support of the ordinance. A couple of things that just want to be clear on, the reason why I support it, and also here based on the commission itself as the Region's chairwoman of the commission. I'm going to talk about one perspective, a portion of it, which is the fine section. We've had discussions with DEEP relative to the fine and how the system works. That part is if a $1,000 a day fine, as I read this, the ordinance has provided, just want to make sure it's clear that the fine is on a daily basis, if not for the occurrence. So as an example, if someone comes in and digs into a wetland on the 1st of October, and they get cited for that violation because they've gone and dug a pond they don't have a permit for it, and we cite them, and if they don't resolve that for 30 days, that's not one violation. Okay? I'm not, because when I read this and some of the feedback we got gave the indication that it was just a single hit for that event. That's not the case talking with with Darcy Winters. The other part is, we've already had this. What we're trying to do is actually kind of really resolve a problem we had with that we encountered in the past, and make this something for our toolbox as we try and deal with people who are violating the regulations. It's not the intention of the Inland Wetland Commission to get anyone from anybody. That is not the goal. What we want is compliance. We want the person to follow through and resolve the issue. We've dealt with individuals in cases of over a year trying to resolve the issue, and we've been able to get compliance. We had an issue where an event took place where we could not get compliance. And so we looked at all the different avenues. There was discussions with town attorney, okay, trying to figure out how do we address this problem. The problem boiled down to a simple thing. Because it cost the town, right, based on my recollection, about $15,000 to resolve this in attorney costs. Here's the kicker. Here's what drives this ordinance in a nutshell. If we have somebody who goes out and makes a violation, and that violation, fines or whatever, comes to be, say, $40,000, the town goes and forces through the judicial system this process. Okay, we spend out this $15,000 because it's been done under the state statute. The $40,000 that comes back does not go to the town. The state, in essence, says, thank you very much for the money, and you pay the attorney bill. So the purpose of this ordinance, and that's what we found out, okay, dealing with the council, because that's where we get the information from, is that if we spend the money for the attorney, we don't get the fine money because we don't have an ordinance that the town owns. So in absence of that, if we don't get the ordinance, what happens is, if you have a problem with anybody, then and you try and force the issue, the town will pay out of their pocket, okay? And that's not appropriate. As an individual town taxpayer, I don't want to spend money for something, knowing that the result's going to be giving the money to the town, and we can't get a reimbursement. To the state, sorry. The state does not give the money to the town. The town is out $15,000 or whatever amount of money, because we should not have to bear that burden. And that's what's driving this. This is not intended for 95% of the people. 95% of the people will comply. It may take them a while, it may be a year, but so be it. That's what, if it takes a year, we understand people have financial issues, it may be the wrong time of season, there are myriad of reasons why someone may not be able to meet our schedule, and all we do is ask them to come in and give us an update. Where are you? What's pushing you off? Okay, that's reasonable. You know, something may have happened. We've had people that had family issues. They said, you know what, I need more time. I need 6 months. Can I come back in 6 months, resolve this issue? Okay, this area's been secured. We can come back and you can resolve it later date. So the reason I stay up here, and the reason I talk about some other issues relative to it, is that we're already in a position that we can do this based on statute. That's the right of the commission to do. The only issue is that we have to go to court and we have to pay an attorney to force an issue after all this effort. Is the town pays the attorney fees, and you don't get any of the money if you click on the other side. In the one particular case, we ended up needing a piece of property for a lot of money, and the lien wasn't a problem until I would say, heirs took possession of the property and said, I got to clear the lien. And at that time, they cleared the lien. Okay? But on the same token, we don't want it to become, from a developer's perspective, and now I use some of my own personal experiences working construction, is the cost to do business may be such that digging the pond and causing the impact that's a violation may be cost effective for me in the short term to pay the bill. Now, I know that doing that in the short term, the town's going to say, you know what, you filled the wetlands in, and I did it intentionally. After somebody has come in front of the commission and said, and we told them, do not do this, and they go in, they fill the wetland in, then we chase them to fix it, that may be a case where the person decided, and they may not be able to not have to pay the fine. Okay? Because there are cases where people have done things which we've been very clear about not doing, and they've skirted around the edges. Okay, so this is a tool in the toolbox. It's not a tool you want to use, maybe less than 1% of the time, but if we have to pull it out, let's follow it with somebody else's money, not taxpayers' money, when we get to resolution. Because if we have to go this route, it's usually lots of fines, lots of costs, and then I think the biggest thing that took place last time, this is the last thing to say, the biggest thing that worked against us is that, and this may not take it as you will, the town did not have the stomach to want to pay the fine, pay the cost, to fight the battle, knowing that it was all coming out of their pocket, which is a reasonable expectation. Nobody wants to buy something for somebody else when they get nothing. They're going to get no benefit, or if they're going to pay for a benefit, it's going to go to somebody else. So that just extends the length of time you got to fight something. And we don't want to set a precedent where if you come into town, Ledyard, you come in front of the Inland Wetland Commission, you do something you're not supposed to do, you know you shouldn't do it. And as a little side note, developers who come in front of us, they know all the hoops, they know all the things to do, okay? You get property owners who come in who don't know. I just left the football field, someone asked me about something with their yard, they go, do I have to go talk to anybody, do I have to go to zoning, do I have to go, hey, yeah, the general public really has no clue. And we on the commission, we understand that. We spent an hour last night, as an example, talking to somebody who wants to build a house, and all the paperwork they've got to get. We know they're having issues. I'm not trying to drag this thing out because I got to do something else shortly. Football, sorry, but I stand in support of this ordinance because if we have to ever use it, then we have the ability to, at the end of the conclusion, to be reimbursed for our cost, and that's really what drives this. Thank you.
Thank you.
Question, go ahead.
I want to clarify the violation part of this. I'm looking at an analysis of Rocky Hill's ordinance that is put forward by the DEP as a model regulation. And it says their ordinance provides for a fine of up to $1,000 per violation as authorized by Connecticut General Statute 22A-42G. And the ordinance specifies that each day of a continuing violation is a separate offense.
Correct.
However, it then says it is not clear that this provision is authorized by the statute.
Actually, it is.
If
If you read sections of the statute 22 alpha tac 42 subsection bravo, it actually states in that section of the statute that any person who takes part in or assist in any violation of any provision of sections 22.836 to 22.845 inclusive, including regulations adopted by the Commission, ordinance and regulations promulgated by municipalities and districts and pursuant to the grant of authority herein contained, shall assess the civil penalty of not more than $1,000 for each offense. Each violation of said section shall be separate and distinct offenses, and in the case of a continuing violation, each day's continuance thereof shall be deemed to be a separate and distinct offense.
Okay, because that's not what I understood.
That's the enabling statute. So the way that this is, in my opinion, the way that the ordinance is currently worded is based upon what the statute defines as a violation. So the overriding statute for wetlands provides the definition that says
Yes.
that every day is a new violation. And I agree with what you're saying on that point. So I don't think we need to go into any more detail in the ordinance because the enabling statute provides that information.
And you cite in section 4, processed in accordance with
Right.
ordinance 118. Okay.
So 118 files the hearing procedure, which is the zoning citation similar to this one.
Okay. Because that's not what I thought I heard.
Yep.
Okay, I just wanted to remind everybody this is the public hearing, and we can have some of this discussion when we discuss it.
I'm good now.
Thank you for your service, and thank you for being here this evening. Are there any other public comments?
Lynn Thompson, I'm the president of Ledyard, Westbury, and also the chair of the Plus Commission. I'm submitting also for your review an OLR research report dated December 10, 2010, completed by Janet Kaminsky, a senior legislative attorney with the Connecticut State, with Connecticut legal system. And this indicates anyone willfully or knowingly violating the law is subject to criminal penalties, including one for the first offense, a fine of up to $1,000 per day, imprisonment of up to 6 months, and for each subsequent offense, and then there's additional fines. If you will actually look on the website, you'll see that a number of attorneys have now determined it to be, it's a daily amount. When it first came out, the language was just a single event, but they have interpreted it to be on an ongoing daily basis. I'm going to kind of review it a little bit different way. Sometimes things take a spin, and language evolves, which characterizes a simple request, which is actually in the town's best interest to save you money if we have to do something fine. Here are some of the myths behind a simple but 2-year-long process that we've been undergoing to get this ordinance in place. Myth number 1. they will arbitrarily use this ordinance. They is a commission of 7 citizens from all walks of life, ages, gender, and demographics. They've been nominated by citizens of this community and appointed by the town council. There is no they, it's a we. There is no arbitrarily, since the job of the Wetlands Commission is to interpret and enforce state guidelines to serve the citizens of Ledyard and the greater good. The second myth, they will run roughshod to accomplish their goals. Our total goal of the IWWC, as Michael explained, is compliance with the regulations that support the desires and needs of both the long-term and short-term benefit. In all of 30 years, there's been 1 fine assigned. That was done in communications with the property owner, multiple fieldworks, concurrence of all commissioners, and discussion and advice of the mayor and the town attorney. Nothing this serious can ever be lightly done. The goal in this case was to protect the brook from use as a road and a haven for trash. Myth number 3, if we won't pass this ordinance, then we won't have any fines. Not right. State law allows the IWWC to administer fines. What will change as a result of this ordinance is that the fines collected will go to the town, specifically the legislation says the town's general fund, instead of going to the state. There will also be an identified process for appeals, an identification of what needs to be in place to begin the process. In reviewing the ordinance, there were some specific small requests we'd like for you to think about. 1, we would like for you to refer to the enabling statute by number in the ordinance itself. Number 2, we would like you to keep the name of the ordinance consistent throughout the document. It changes from place to place. And number 3, we would like you to think about the passing of a motion, changing that first of all to a simple majority, and then we'd like you to determine whether it's voting members, members who are present, because remember, we have a quorum of 3, we have regular members of 5, and alternate members of 2. So it would be really helpful if you could clarify for us who the simple majority are in terms of making this decision.
Could you repeat that last? You have 3?
We have 3 to be a quorum,
Okay.
5 regular members, and 2 additional alternate members.
Okay.
Alternate members don't vote, the regular membership is there. So just be real specific.
I can clarify that. The way that this is worded,
Okay.
it's a super majority. So you need 4 votes to pass.
Okay.
So
Cool.
it doesn't matter. Whoever seated the vote can vote.
Whoever sees
Yeah,
the vote. So if we have 7 people there, typically 5 vote, the 2 alternates don't vote. So it would be of the 5.
Whoever the voting members are for that.
Whoever's voting. Okay, great. Thank you very much.
Thank you, and thank you for your service. Any other public comment?
I only want one question, Marie.
Yeah,
Which
sorry.
statute, which specific statute section do you want us to reference?
As I looked at that,
Because right now, the enabling statute that allows you to set the fine is what we,
okay, so that would be
22.
22G,
Yeah, 42.
44.
no, 22A 42G
42A.
allows the municipality to pass the ordinance.
Okay,
And that's already referenced in the ordinance.
Okay, I would ask you just to recheck that, only because there's a section of them, 36 through 45, that relate to what we're doing, and we'll make sure we have the exact right one.
It
and
is
then
in there.
make
It is.
that.
It is
It
in
is
there.
in it.
Okay, then I'm good.
Yeah, 42G allows municipal fines.
Yes.
That's the statute we
Okay,
referenced.
that would be good then.
Gotta be short. Hi, Mike Cherry, 5 Whipple Drive, Gales Ferry. I'm also chairman of the Planning and Zoning Commission. At the last attempt at passing this ordinance, I had risen opposed to the ordinance, not to the concept of a citation ordinance for in wetlands, but the way it was worded. It wasn't clear on the fine being a daily basis. It wasn't clear after the decision to cite is made, what happens. Those things have been clarified, and I agree with Mike. The purpose of the toolbox is to enforce compliance, and I think this one does it much better than the last one. As a side note, backing up what Lynn Maria said, zoning has had a citation ordinance for a long time. I think it's like 10 years. And having that in the toolbox has prevented us from having to use it. So thank you to those who took time to rewrite the ordinance to make it clear, and I withdraw my objection.
Thank you. Are there any other public comments? Hearing none, this public hearing will adjourn, and for the listening audience, I would just say that we will now take this up as an agenda item at our regular meeting at 7 o'clock.